So welcome everyone. We are so excited to have you in class today. My name is Curry Sautner and I'm the Chief Learning Officer here at the National Constitution Center. And today I get to be your host on our conversation, our fun-sided conversation on the Second Amendment. And the best part about this is on Fridays, we bring in guest VIP speakers. And our professor today is Professor Clark Neily from the Cato Institute. So before I get to go in your long bio, Clark, welcome. We're so excited to have you here today.
It's great to be here. Thanks for having me.
And I was warning the students before we started that I worked with you on the Fourth Amendment with policing. So if I mistakenly, what I did to you, I say Fourth Amendment, that they're going to correct me in the chat. But I think it's like an extra bonus that, I mean, you are a constitutional lawyer, but you also do a lot of work with policing and privacy, and that overlaps with the Second Amendment so often. So if we go a little sideways on that, students, our professor today can handle it and will help us out as well. So thank you so much.
You bet.
So exciting. So before we get started, Professor Neily he's the Senior Vice President of Legal Studies at the Cato Institute. And his areas of study include constitutional law, overcriminalization, coercive plea bargaining, and we had a question for you about this last week when we did do the Fourth Amendment, so maybe we'll sneak it in at the end, police accountability, and gun rights. You're also what I lovingly refer to as not just a scholar and a professor, but you're also a primary source because you were the co-counsel on the Heller case, correct?
Yep, that's right.
So you're like a part of history. We could put you in the museum if you were here. And we're excited about that as well. So lots of questions for you today. We're going to dive into the Second Amendment. We're going to unpack the words of the Second Amendment and then walk through time and really understand how the Second Amendment has been understood at different time periods and the words of the Second Amendment. So Professor Neily, I sometimes say that this class winds up being like an English class as well, as we're trying to define the words so we understand them together as a community of learners that we are. But I also want to remind our students that this is a hard topic and it's a constitutional conversation. So we'll talk about multiple sides of this, but we're going to talk about the constitutional questions on this. There's a lot of times with these harder topics, a lot of people talk about, well, we should be doing this or we should be doing that. We're going to look at the Constitution and say, what may we do under the Constitution and where is the government limited under the Constitution? I know we taught this class on Wednesday and it was definitely tricky for some of our students to grapple with the pieces. And we're going to ask you questions about laws that are happening in the states as well. So Professor Neily, thank you so much for being here. And we always like to start with the Constitution. So would you mind walking us through the words of the Constitution on the Second Amendment and unpacking them?
Absolutely. And I want to start by sort of trying to frame a context, which is that I think one of the biggest mistakes that people make is to fail to appreciate the words in context. All meaning to some extent is contextual. Consider some of the most precise language in the Constitution, right? That says you have to be 35 years old to be president. Even that requires some context now that we've begun to explore other planets in the solar system. What if we colonize Mars? They have a different, their solar year is a different period of time than ours is. So even that requires some context. And when we're talking about rights, I think one of the most important contexts to appreciate is that the framers of the Constitution and many scholars and lawyers today, myself included, believe that the Constitution does not create rights, that instead the Constitution acknowledges rights, and in some cases, it fails to acknowledge rights that nevertheless exist and can be constitutionally protected. I'll give you one example that is far from controversial. In the early 1900s, the Supreme Court held in a pair of cases called Pierce and Myers that parents have a right to guide the upbringing of their children. That right is not mentioned anywhere in the text of the Constitution, and yet the Supreme Court held, and I believe uncontroversially, that you do have that right. So that's the context in which I think about the Second Amendment, and I reject the idea that if the Constitution either fails to mention a particular right or discusses that right in a way that is potentially confusing or doesn't resonate, with the modern ear, that therefore the right doesn't exist. And I would include very much in the list of rights that are not expressly mentioned in the Constitution, but nevertheless exist and are enforceable, a basic right to defend yourself. Not necessarily with a gun, that's something we'll get into in a moment, but the idea that each and every one of us has a natural right to defend themselves against sudden violence or even, an attack by a wild animal, which is a thing that still happens sometimes, I think is, again, largely uncontroversial, but not spelled out in the text of the Constitution. I think that matters. So now we're talking about the Second Amendment specifically, and the language of the Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And as I'm sure most of you know, this has given rise to essentially two schools of thought. One school puts a tremendous amount of emphasis on what we call the prefatory clause of the Second Amendment, and essentially says, look, this speaks to being armed only in the context of some kind of militia service. And it's really not an individual right, or at least not an individual right that you can enforce outside the context of some kind of militia service. The second camp, which is the one that ultimately prevailed in the Heller case from 2008, is one that says the operative clause, the second clause of the Second Amendment, is where most of the action is, and the one that really speaks to the substance of the right at issue. And just as it says, the right of the people to keep and bear arms cannot be infringed, and therefore, or shall not be infringed. And what this entails is that individuals have a right to both keep and carry firearms. Now, like all constitutional rights, it is, of course, limited. Even the rights in the First Amendment that many people consider to be sacrosanct, like freedom of expression or freedom of religion, even those rights are subject to limitations. The ability to speak even is not unfettered. There are some things that the government can prevent you from doing. And the same is true with the Second Amendment. Whichever interpretation of the Second Amendment you happen to embrace, it will come with significant limits, and those have yet to really be spelled out by the Supreme Court. But where things stand right now is that the Supreme Court has held 5-4 in the Heller case that individuals do have a right to keep a gun at home for self-defense. And there's a case pending right now that we will presumably get hopefully a merits decision within the next 4 to 6 weeks that essentially asks the follow-up question: is there a right also to carry a gun outside the home? And if so, how can the government regulate that right? So that's where we stand, where things stand today.
Yeah, and there's a lot going on, and I really appreciate that as you're defining this and saying, like, this is what the words say, this is kind of how the courts have given weight and meaning to these words over time, but also where the limits are on the Constitution. We see that clearly with First Amendment. We talk about it all the time. We see it with other amendments, other parts of the Constitution. But sometimes we forget it when we're in dialogues around the Second Amendment. So we have to be reminded of those pieces. I also really appreciate you pointing out, it's not just within the words, it's other amendments that spell this out, or it doesn't have to be spelled out directly. And, nod a little nod to the Ninth Amendment there too, like adding that in there. There's the catch-all. Don't worry. If it doesn't say it, doesn't mean it isn't in there. And the idea, and we've talked about this in class before, that certain rights are natural rights and they don't need to be spelled out. And how do we bring that into the conversation? Now, if you don't mind, before we get to the cases that really start to help us define and understand how the courts see these two different clauses, prefatory, first clause, second clause, sometimes I just make it easier that way. Can we talk about some of the words in the Second Amendment and what the founding generation, why they put it in the Bill of Rights? So it's not in. What are the nods to the structural constitution that may talk about these ideas of militias, of standing armies? How did they feel about these ideas back then? And then in 1791, when they added the Second Amendment, what were they trying to clarify? And where were some of the ideas they get these ideas from? So we always like to talk about the lived experiences of everyone, and that includes the founding generation. So tell us, story time. Tell us a little bit about the lived experience of the founding generation and why they were so adamant about putting the Second Amendment into the Constitution.
Yeah, so a lot to unpack there, but let's start with this. They were in a bit of a bind because they had just spent about 8 years in combat with the most powerful nation on earth, Great Britain, here on the North American continent, and they were very leery of the idea of a big national government, because they had just gotten finished fighting one off and being tyrannized by one. And so what we had for a period of time was the Articles of Confederation, where essentially you had a bunch of individual former colonies, now states, that were essentially trying to coexist and work together. It really wasn't working. There were a lot of problems with, essentially, are we a country or not a country? We're just a collection of states. And so there was this impetus to come together and essentially come up with a better plan. And the real, sort of innovation that emerged from the Constitutional Convention was the idea of creating this new government, a national government, and a new country. But this made a lot of people very nervous, because some of the people said, this looks a lot like this country we just got finished fighting with, because they were tyrannizing us. What guarantee do we have that this new national government that we create won't just turn around and boss us around and oppress us in the same way that Great Britain did? And that was really where most of the action was. So there was two, sort of factions that emerged: the Federalists, who supported the Constitution and the creation of a new national government, the United States of America, and the Anti-Federalists, who essentially felt, nope, the risk is too great. We are not reassured about our safety, and we're afraid that essentially we're creating a kind of a Frankenstein's monster that is just going to, be too strong for us to control, and will quickly become oppressive. And one of the things that was very much on people's minds was whether this new national government, this new United States of America, would be able to have a standing army, standing navy, and this army that it can use to go out potentially and oppress us the same way we were oppressed by the British redcoats. And one of the things that the Federalists pointed out, the supporters of the Constitution pointed out, is that even though the Constitution, which was not yet ratified at the time, does empower the federal government to create a standing army, which is a very scary thing for many people back then, that it would be difficult and perhaps impossible for this notional government, the United States, to oppress the people. Why? Because the people would be able to come together and fight off the federal government if push came to shove. And the reason they would be able to do that is that the Constitution does not empower the government to disarm the citizens. And most people back then had guns. That's something everybody should understand. Most people were farmers back then. Most people lived in relatively rural areas. And I would say that firearms during the founding era were roughly the equivalent. It was to them what our smartphones are to us. If you're going more than about 50 or 100 feet from your home, you bring a gun. And that's just how it was back then. So the idea was essentially that it's not that dangerous to create the United States. It's not that dangerous to empower it to create a standing army, because we have a tradition of individual arms ownership in this country. And just as we rose up as a kind of a single unified people against Great Britain to throw off the yoke of tyranny, we could do the same thing if necessary against the U.S. government. And the sort of the fighting unit that ordinary citizens will form when they come together with their private arms to resist tyranny would be a militia. And a militia was a much different thing back in the founding era than it is today. Most people think of the militia now as, that's kind of like the National Guard. No, during the founding era, they would have considered the National Guard, which is under the complete control of the federal government, they would have considered that to be a standing army. A militia is a much more locally organized and directed kind of fighting force that not only can, but does counterbalance the military force of an official federal standing army. So that's really the significance of the word militia in the Second Amendment. It is not a National Guard. It is not the kind of fighting force that's under the control of a federal government. On the contrary, it's the kind of fighting force that is organic and local, that can pull together when necessary to resist tyranny.
Awesome. And now I have like 32 more questions before we move out of the colonial period. So sorry. And students, you can ask questions too. Put them in the chat, put them in the Q&A, and I will get to them. And Robert Hobgood class, thank you for already starting that. So a couple of questions, and then I want to move to like the end of the Civil War. We're going to time jump and then hit, really dive deep into that modern case in the court.
Yep.
And the Hobgood class already has an awesome question on that. So one, if the idea of the Second Amendment during the founding period, so 1791, when the Bill of Rights was added, so the Constitution already exists, it's added to the Constitution, was for the local people to be able to come together and push back on a government that was using a standing army or could use a standing army to take away rights, take away liberty. The question I have is, that doesn't really play out today, because there's no way that, you know, a gun that I have today is anywhere equal to what like the army or the military had. As we, you know, jokingly say, like, I don't own a bazooka. I don't own, you know, all these other, I don't know anything about weapons, so I'm kind of bad at this, but you know my point here. Yeah. I know a cannon, and I knew that was not appropriately said at the time. I own a potato cannon, but not a real cannon. So how does that play out in that conversation, that it's not able to be one-to-one? And that's really clear in a lot of debates over time, that a regular person in a community couldn't own a mass destructive weapon. It's really the way to ask the question.
Yeah, so great question. I think there are 2 points to make. One is to touch on what I think is another kind of fallacy, and that's the idea that constitutional rights have very particular ends. There's like one reason for having it. Think about the First Amendment. How much sense would it make if somebody said, oh, the reason to have a First Amendment that protects freedom of expression is so people can argue about politics. But if you just want to recite poetry, that's not covered by the First Amendment, because it doesn't, you know, it's not instrumental. It doesn't advance some. No, you have a right of free expression because the government has no business outside of a very small number of areas silencing you. So we don't protect the right of freedom of expression because, you know, we sort of look at our constitutions. Oh, yeah, they put it in there so that people could do politics. No, that is a position that has been advanced but not persuasively. And I would say the same thing about the right to own weapons. It's not in there for one. It's like there was a particular thing that may have prompted them to put the Second Amendment in the Constitution, but it's not as if, oh, the only reason why we protect the right to own guns is so that you can resist government tyranny. No, that's just one of many reasons that people, you know, may wish to own guns. But the right to own weapons is not categorically distinct from the right of free expression. You don't have to convince somebody that what you plan to say somehow promotes civic order or, you know, the good of the country in order for you to have a right to say it. You have a right to say it because the government has no business telling you otherwise. That's my view of the Second Amendment and arms ownership. You don't have to justify. You don't have to say, well, I need a gun, so if in case the government gets tyrannical, I can help resist it. No, you have a right to own a gun because that's a natural right, and it helps facilitate your natural right of self-defense, and you don't have to justify it to anybody any more than you have to justify your right to speak. Second point, and I think perhaps another fallacy, is the idea that in order to effectively resist tyranny, you have to be able to defeat the tyrannizers, the tyrannizing government in combat. That's not true. What you have to be able to do is you have to make it more costly than they're willing to pay. We've seen this in Afghanistan, Iraq. We're seeing it in Ukraine now. It is absolutely possible to resist tyranny using weapons that would not enable you to defeat the oppressor militarily, but you don't have to achieve military victory in order to make them stop oppressing you. You just have to be able to inflict a sufficient amount of casualties and costs on them that the price is too high and they finally either withdraw or cease their oppressive behavior. And those are two much different scenarios. So you're right. We would not, a group of citizens owned with handguns and, you know, rifles and shotguns would not be able to defeat the United States military in combat, but they don't have to. They just have to be able to inflict enough costs that the price of you know, oppressing that population is too high and people aren't willing to pay it. And we see that. I just read a story this morning about how Russian soldiers are literally refusing to serve in the theater of operations in Ukraine. They're literally quitting the army before, and that's, you know, I think at least part of that is because they have no interest in going and trying to oppress a bunch of Ukrainians, especially who've been fighting back so effectively, despite the fact that they're not a nuclear power and they don't have the same kind of armaments as the Russians do. Hopefully that makes the point.
Totally point. And we were talking about it on Wednesday. So I really appreciate you going in that. We were seeing just these similarities between this conversation in Ukraine. So thank you so much for bringing that up. It also gives me like flashbacks because I think it was like the 80s movie Red Dawn.
Yes.
But like
Wolverines.
And all the kids now are like, we don't know what you're talking about. Don't watch the second version. Watch the original. Way better. Definitely. Patrick Swayze. Okay, before we go on to the Civil War, and questions are already around, like, again, what is a militia and how does that change over time? What does a militia look like after the Civil War? What does a militia look like today? And what are the conversations around that? Could you just define arms for us before we jump into that? Because that's another sticky word for a lot of us when we're trying to unpack this. history and unpack this understanding. What does that mean? Somebody in Wednesday's class asked, could they say that, oh, you're allowed to have arms, but we're categorizing these arms under slingshots? It was being dramatic, but it was a good example.
Yeah. Okay. So this is another question that's challenging, but not categorically distinct from the other kinds of questions we have to answer when we do constitutional law. The First Amendment prevents the government from infringing your freedom of speech. Well, what does speech mean exactly? Here's a question from, I think, 1989, or at least in the 1980s. If you're burning an American flag, are you engaged in speech, or is that an act? And that divided the court 5-4 in a case called Texas v. Johnson. 5 justices, correctly in my view, held that burning a flag is an act of constitutionally protected expression, even though it's not literally speech. So what do arms mean? Well, arms mean weapons. Arms mean essentially anything that you might pick up to make yourself more effective at fighting or defending yourself. It doesn't even have to be fighting another human being. I've actually, believe it or not, I was on the phone a couple of years ago for about 45 minutes with a reporter talking about whether there's a constitutional right to defend yourself against a wild animal, because this comes up from time to time. There was a man who was prosecuted for shooting a black bear out of season in Colorado. It was a felony prosecution. His only defense was that he felt the bear was a threat to himself and his family, and that's why he shot it out of season. And so getting back to the specific question of what are arms, again, it's not a difficult concept. It's effectively, any weapon that could make you more effective at defending yourself or defeating another person or animal in combat. And it could, and these cases have arisen. They're very fascinating cases. Are knives covered by the Second Amendment? I was talking to a lawyer up in Long Island last night. I had an event. He was on the government side of a case where a man was brought a Second Amendment challenge to a New York law that prohibits people from owning nunchucks. I don't know if anybody's ever seen any Bruce Lee movies, but the nunchucks are the things you spin around like this. And there was a case out of Massachusetts where Massachusetts prohibited people from carrying pepper spray. And the Supreme Court said, yeah, no, pepper spray is definitely included within the ambit of the Second Amendment. Of course, where it gets challenging is when we talk about, like weapons of mass destruction and weapons that the Supreme Court described in Heller as unusually dangerous or unusual weapons. And there's going to be line drawing there, just like there's line drawing with every single other part of the Constitution. And reasonable people can differ. I personally think it's quite clear that ordinary people are not, the Second Amendment does not protect the right to own things like nuclear weapons, anti-aircraft missiles, a tank, and it gets harder there, believe it or not. Some people would say, oh, well, it doesn't protect your right to own artillery either, like a cannon or a howitzer. Well, maybe it does, actually. There's a provision in the Constitution that empowers the federal government to issue something called letters of marque and reprisal. And essentially what these were was a congressional authorization for you to go out and be a pirate, as long as you were attacking the right people. And guess what you would need to equip your ship with if you were going to attack the maritime commerce of another country? You would need cannons on that ship. And so conceivably, contextually, there would have been a right to own at least some kinds of large kind of crew-served weapons like that. Would the Supreme Court protect that today? Absolutely not. Doctrine changes over time. I'm pretty sure that the Supreme Court will also not protect, if anybody ever tries to take a case to the Supreme Court under the Second Amendment involving fully automatic weapons, which are commonly called machine guns. I don't think there's any possibility the Supreme Court would find those to be within the ambit of the Second Amendment definition of arms, even though I think you could make a pretty strong originalist case that they should be, particularly because, as we talked about before, part of the reason for acknowledging the right to keep and bear arms is to make people more effective in their ability to resist a tyrannical government. A fully automatic weapon would be helpful in that regard. But Supreme Court tends to be pretty pragmatic. We do things, there's almost always balancing going on, even when they deny that it is. And I'm quite confident that the Supreme Court will never hold that fully automatic machine guns are protected under the Second Amendment.
Fantastic. A lot to kind of keep going through, but that was really helpful to understand and kind of see how are arms defined, and then again layering on where the limits on those arms, but also where they won't put the limits on those arms too. And I think it's really interesting. And I'm pretty sure pepper spray certain types of pepper spray are in Pennsylvania are not allowed. So like there's certain ones that like I can have as an individual and different ones that police officers can have as police officers as well. I went up running in the woods a lot. So pepper spray is not a bad thing to have. Okay, so next question is, I wanted to jump really quickly, and I know we have about 35 minutes, 40 minutes on this. We always stretch it a little further on Fridays. So after the Civil War, I found this history really fascinating. Looking around the Civil Rights Act of 1866, if I think I get that year right, but also looking at the Black codes and trying to shift this understanding of individuals' rights, and also bringing in this idea of militia and who are the militia. When we talk about this history, it always unpacks for me this understanding that sometimes your local government isn't going to come help you, and you need to be able to save yourself. And we were talking about this during people that were oppressed by racist groups and African Americans who were oppressed by racist groups. And we always talk about the Ida B. Wells quote, the best thing for an African American is a Winchester, because maybe if a white supremacist life goes down when a Black person's goes down, they'll think twice before they do it again. That's a butchering of the quote. I will send the real one. But can you talk about that moment in history? Because it was a big eye opener for me in learning that history, and we don't talk about it often.
Yeah, no, I appreciate that. I mean, look, this is next to slavery. This is probably the ugliest moment in our nation's history. It was the advent of what we call the Jim Crow era, where we fought this Civil War in part to settle the question of whether slavery would be permitted in the United States. The answer, of course, was no. The 13th Amendment was ratified and legally eliminated slavery as an institution. The problem was that in many states in the South, both the governments of those states and the people essentially tried to continue to treat newly freed Black people. The term then was freedmen. To keep them in a state of constructive servitude by essentially refusing to recognize various rights that they had. And that would include, for example, things. There were laws against leaving your employer's property without permission, right? Your employer's property, in case you need me to spell it out, was a plantation. And so, in effect, they were continued to treat the freedmen as enslaved people, just without the formal trappings of slavery as a legal institution. And, one of the ugliest aspects of this time was the use of terror to keep newly freed Black people in a state of oppression. And this was the beginning, where the Ku Klux Klan began to organize. And it was both private individuals and in some cases government officials who engaged in campaigns of terror, essentially just to communicate the message to the freedmen that if you try to exercise the rights that the federal government has said that you now possess, both through the Civil Rights Act of 1866 and then later the 14th Amendment, which was ratified in 1868. If you try to exercise those individual rights, there will be retribution. And so don't even think about it. So one of the rights that was most frequently discussed in the run-up to the 14th Amendment was the need to ensure that not only the freedmen, but also their white supporters could be armed in order to resist and defend themselves against these overt efforts to oppress them and to intimidate them through campaigns of terror. And let me spell out what I'm talking about with campaigns of terror. I'm talking about lynchings. I'm talking about people riding into your homestead at night and pulling the father out of the house and hanging him from a tree. Or if they were in a good mood, maybe just tying him to that tree and bullwhipping him. So there was a tremendous amount of discussion about the need to protect individual gun ownership during this time, so that these individuals who are being terrorized and oppressed would have the means to protect themselves and to push back. And there's really not a great deal of debate about this. I think virtually all historians acknowledge that this is something that was happening and that was very much on the minds of the Reconstruction Congress when they drafted and ultimately presented the 14th Amendment to the states for ratification. So I think the case for individual arms ownership is, if anything, even stronger under the 14th Amendment than it is under the Second Amendment, precisely because of this history.
And thank you for bringing up what that violence was, because that's Ida B. Wells says that statement, and she is a huge champion for ending lynching. And then I have Rosa Parks behind me. We always talk about Rosa Parks and the bus, but Rosa Parks did work in protecting and defending so many African-American women that had sexual violence against them as well. So it really, we know we have younger kids and we don't want to be overly graphic, but we also need to understand the level of violence that we're talking about. Now, as we jump into Heller and McDonald and even the rifle case now in the Supreme Court, Robert's class has 2 questions I'm going to weave in, but I'd also love for you to tell us what it was like to be on a Supreme Court case, and what do you have to build to be able to build your argument? Because so many of our students, something you need to learn in school, but in life, is how do you build a good argument? And then Robert Havergood's class first question really wants to ask you and understand with the rifle case, how would you build the opposite group's argument, the one that you would naturally refute? How do you build the other side of it? Because that's a great skill of a great lawyer as well, and a great a debater.
Yeah, no, it's a great question. I mean, look, so we stand on the shoulders of others, and in some cases, we stand on the shoulders of giants like Thurgood Marshall. If you ever go and look at a cathedral, for example, and this is my experience when I see this massive cathedral, I think, how could anybody know how to build that? And part of the answer is that they didn't have to start from scratch, right? And so whatever the most rudimentary structure that a person can build is, maybe like a mud hut, we learn how to do that, and then another generation comes along and learns how to turn that into a house, and then another generation turns it into a church, and then another generation turns it into a cathedral. Civil rights litigation is very much like that. And so the kind of blueprint for the sort of civil rights litigation that we considered the Heller case to be, that was really mapped out by people like Thurgood Marshall and his colleagues in the NAACP in the 1950s and the 1960s. And they really, sort of laid down the basics for what you do when you want to try to vindicate a particular right. And there's a few basic points. First, you try to present the right to the Supreme Court in the most sympathetic setting that you can. So, for example, we didn't want the Second Amendment to be presented to the Supreme Court in the context of a criminal prosecution, right? Somebody who maybe stuck up a liquor store and he says, well, I shouldn't have done that, but I did have a Second Amendment right to the gun that I used. That's a bad factual setting, obviously. So what you try to do is try to create a more sympathetic factual setting, which is what we did. We went out and recruited plaintiffs to be part of this challenge here in Washington, D.C. And we didn't pick Washington, D.C. by accident. We picked it because first, it had probably the most sweeping gun restrictions of any jurisdiction in the country. And second, the local federal court of appeals was one of the only ones that had not weighed in on the question of the Second Amendment yet. So we weren't going up against adverse precedent. It was a blank slate. And we recruited plaintiffs here, very sympathetic people. You've only ever heard about Dick Heller because for reasons that I won't try to unpack right now, 5 of our 6 plaintiffs were found not to have standing, which means they were found not to be eligible to be plaintiffs in the case. I disagree with that ruling, but Dick Heller was found to have standing. But I'll just give you a couple of really quick examples. The original lead plaintiff was a woman named Shelley Parker, who had an apartment in what a real estate broker would call a transitional neighborhood, where they were selling drugs right on the street. She pushed back against that. She would go out and call the police on these guys and tell them that she had done that. One of them threw a rock through the windshield of her car, and one of them actually tried to kick his way into her apartment while threatening to kill her. And she felt very strongly that she wanted to be able to defend herself if that person ever came through the door, and she wanted to be able to have a gun to do that, but it was forbidden in DC. One other quick example, another plaintiff in the case was Tom Palmer, who was then a senior vice president here at the Cato Institute where I work. He was almost murdered in California because he's openly gay, and a skinhead mob figured that out and pursued him and actually cornered him. He was able to save his own life because his mother had given him a pistol that he carried in a backpack, even though he didn't have a license for it because he couldn't get one in California at the time. And he was able to save his own life, didn't have to shoot anybody. He simply pointed the pistol at the skinhead mob and told them to back off, which they did. So these are people with very relatable stories, people who are very appealing. And what you try to do is put together a group of people like that who are, again, sort of very sympathetic and relatable proponents of the right that you're trying to vindicate. And then the last thing you do is you try to figure out how can you present this right to the Supreme Court in the sort of the most non-threatening posture. Ask them for the smallest amount of relief that you can. So you're not asking them to take a big step, you're asking them to take a little step. And that's essentially, those are the outlines of a successful public interest case. And again, we stand on the shoulders of giants here. We didn't have to figure this out ourselves. this blueprint had already been created and field tested by lawyers far more accomplished than myself. And the answer to your question is, what is it like to be part of a Supreme Court case? It is exhilarating. It's terrifying at times. And it's a lot of really hard work. You need about an equal measure of hard work and luck to get a case to the Supreme Court.
That's fantastic. I appreciate it. And we've had in class, and some of our students have come to this class on Brown v. Board of Ed, and looking at that strategy about, let's start with college. Because if we start with the little kids, people are going to flip out. But if we start with college and chip away at that wall of segregation, then we'll be able to build it up. So there's so much strategy that goes into this. And you just hear these big moments in time. Oh, Brown v. Board of Ed was one, but you don't watch the hundreds of years it takes to get there. So Thank you for breaking that down and kind of explaining it to us. And then students, again, it doesn't matter what the case, you can apply those theories to any of them. I guess the second, second question around this is talking about, we'd love to unpack the rifle case now. And some questions in the chat were also, I know Jennifer wanted to understand, how does the Second Amendment apply to the right to carry a concealed gun? So what's the difference between in the house, out of the house? I always get really confused about when it's concealed and when it's open carry, because I have to be honest, I feel like open carry feels worse to me, but that's not always how the courts see it. So I'm almost backwards in that. And then our final question, I'll save to the very end, but I want to wrap up with, legislation around limiting guns in school shootings. And I know that's a heavy ask for the last one, but I know you've talked about it before and we can pull a couple cases. So let's start with concealed carries and the case in the courts now.
Yeah, so, now that the Supreme Court has determined that the Second Amendment protects an individual right to own a gun at home, the natural question after that is, well, what about the right to carry a gun outside the home? After all, the Second Amendment refers to the right to keep and bear arms, and this at least suggests that there might be a right to carry a gun outside the home. And if you think about it, that would make sense, right? Because where are you most likely to be attacked? Where are you most likely to need to be able to defend yourself? It's actually not in the home. You're more likely to be attacked outside of your home. And so a right to own a gun for self-protection, but that can only be exercised within the four walls of your own home is not as obviously robust or protective as a right that to take that gun with you outside the home. But on the other hand, of course, that also increases the stakes for public safety, right? Because if you've got people carrying weapons outside of the home, that represents a potential threat to the safety of other people. So it is a significant step forward. So the way that carrying guns outside of the home is regulated now falls into three different categories. First, most states, about 35 or 36 states, have what are called shall issue permitting schemes. And that's very much like getting a driver's license. There's no discretion involved. If you meet certain criteria, sometimes you have to take a class, you have to have no criminal background, et cetera, then they have to give you the license to carry. And they can attach some conditions to that in terms of where you can carry a gun, whether you can take it into a restaurant or a bar that serves alcohol, et cetera. But they have to give you a license. And that's, again, about 35, 36 states. There's about a dozen states that actually don't license guns at all. There's no permitting process. You don't have to go and apply to a permit. You can just carry a gun if you want. And believe it or not, the first state was Vermont. Vermont has never had a permit requirement in its entire history. And of course, we all know what a hellscape Vermont is. So we're getting to about a point where about a third of the states in this country are going to have no permitting whatsoever. If you want to carry a gun, you can do it, provided, again, that you don't have a criminal background, because that's a separate law. There's both federal government and state governments prohibit felons from carrying or even owning guns. The third way of regulating, which is the one that's at issue in the case that's pending in the U.S. Supreme Court right now, which is called the Bruin case, is discretionary. And essentially what it says is that the government gets to decide who can have a permit to carry a gun. And in New York, you have to show special cause. No one knows what that means. There's no definition of it, but it means that you have some special reason why you need to carry a gun that's different from just sort of, in case I'm attacked. And the question in front of the Supreme Court is whether allowing the government to have that much discretion. I mean, imagine if we did driver's licenses that way, right? You have to go down to the local Department of Motor Vehicles and say, I'd really like to have a license to drive a car. And somebody says, well, why? Why do you need to drive a car? I feel like my life would be better. Well, no, you need to be like, do you need to take somebody to the hospital for dialysis or something? Because we don't just let anybody drive a car in this state. That's essentially how it is in New York. And based on the way the argument went, based on the way the questionings from the justices went, it seems unlikely that they will uphold this law. And I think that's not terribly surprising. There's no other constitutional right that I'm aware of where the ability to exercise the right depends entirely on the discretion of some local government official who gets to ask you, like, why do you really need to exercise this right? So I don't think it's going to fly. And then, of course, the other problem, too, is that the people who are trying to advocate for this discretionary permitting system don't really have any good response for why there haven't been problems or why there haven't been more problems in other states. In other words, if you look at California and New York that do the discretionary permitting thing and compare it to states like Texas, or again, Vermont, where there's no requirement to get a permit, you should be able to show some significant difference in public safety outcomes, and they can't. So that's a further problem for the people advocating that law, and I think it's probably going to be struck down. And the result is going to be, I think, that either you have to have basically some non-discretionary, objective criteria for who gets to carry a gun outside the home and who doesn't, just like the way we do with driver's licenses. It's a prediction. I could be wrong, but my gut says that's where we're going to end up at the end of this term.
Awesome. Thank you. And next week, we're going to do the Supreme Court in review and dive into it again. So if you have more questions, students, we can also bring them back next week. The last question I have for you, I know I watched a report, I think it was in February, there was a law coming out of California about safe schools and about legislation to try to stop school shootings. It was a reaction to a school shooting in another state. And I want to understand kind of, we all have conversations about school shootings and how dangerous that is for our students. And what have you seen in those legislation pieces that really kind of make sense and seem like they could move forward? So for people that are looking at this and saying, but we have to do something, we need some type of legislation, or people that are saying, you're aligning some of these licenses with driver's license, and that's not actually that accurate, because driver's license, you have to do a lot. You have to take a test. You have to then be with another, at least in Pennsylvania, you have to be with another driver for 6 months. And then you have to take another test to show your skill. And that's not always the case in each state about how thorough the licensing is, even when they have it. And there's a lot of variability. So maybe you can unpack for us, like, how do we as a community say this is in the Constitution, but there are ways to limit it and come to a healthy kind of compromise to say how we can move this forward?
Yeah, that's great. So a couple of things are important to keep in mind. Contrary to what some people will tell you, some people say, guns are one of the most least regulated consumer items in the country. That's absolutely false. They are the most regulated consumer item in the country. And if you haven't actually tried to go and purchase one, I encourage you to do that. Go and see how many steps it takes to purchase a gun, and then in a state that requires a permit, how many hoops you have to jump through in order to get a permit to carry that gun. It's a substantial and substantially regulated item. And so, we could talk about whether states regulate driver's licenses more or less, but look, that's within the realm of public policy. States get to decide kind of within reason where to set, those limits, or as in some states, not to have a restriction on who can carry a gun. The other thing to talk about when we talk about high school or just school shootings, as horrific as they are, and I've got 2 kids in school, my son is 8, my daughter's 7, is to keep in mind that as horrific as they are still very rare. A shark attack is a horrific thing. There was a woman who was killed by a great white shark in Maine last year when my family was headed up there for vacation. I have relatives up there. She was paddleboarding with her daughter, just like in the bay by Portland, where you wouldn't think this would happen. She was killed by a great white shark. It's horrifying. It's also very rare. Same thing with school shootings. You might not think that, but they remain very rare. And in fact, the safest place for a child to be today is in school, statistically speaking. It's safer than home. It's safer than in the car on the way to school. It's safer than a shopping mall. So schools remain very safe. Now, does that mean that we just throw up our hands and say, well, we're just going to have to accept some number of school shootings? No, of course not. But we have to be, I think, cognizant of what kind of a person goes into a school with a gun and murders a bunch of children. It's a person who by definition is insane, right? And unfortunately, insane doesn't mean incapable of thought. It doesn't mean incapable of planning. In fact, some of these people are very good at planning, and very difficult, to interdict, to identify and prevent. And even, I never use school shooters' names, by the way. Many of them want you to use their names. I never use their names. I don't want to grant them that kind of recognition. But there have been a number of incidents where the person involved sent out many, many, many signals that they were a potential threat, and the system completely failed to do anything about it. And I think that we could do better from a public policy standpoint, but I really don't think this is primarily an issue about guns. It's primarily an issue of, it's not an issue primarily about the guns that are used in school shootings. It's primarily an issue about the people who engage in school shootings. We need to do a better job of identifying people who basically are in a frame of mind where they could do something like that, and ensuring that one way or another they're prevented from doing that. I am rather skeptical of whether, increasing the amount of restrictions that the government puts on guns is likely to be an effective response here. I wish it were. I mean, don't get me wrong. I wish it were. But what we've seen is that when people are determined to get a hold of a weapon, they're going to find a way to do it. And I'm not throwing up my hands. Again, I'm not saying that it's impossible, to have better and worse policies here. It is possible to do better. But I am very skeptical about whether massively increasing gun restrictions is likely to have the effect that we all want it to have, which is to make it more difficult for people, to get a weapon and go shoot up a school or any other place. There are better and worse ways to go about this. Red flag laws are an example. These are laws that empower a court to issue an order to disarm somebody who has been, determined to be potentially, suffering from an acute mental illness. Even those probably are not, magically efficacious, because of course people, they can plan, and they may just go and hide their guns if they know that they're starting to have a mental health episode. I don't want to get too deep in the weeds on that. I think I'll leave it at this. School shootings are horrifying. They are also, thankfully, they continue to be rare, even though you wouldn't think it. They are. A school is the safest place for your child to be, and continues to be the safest place that your child can be. We can do better, but we have to try and do better in a way that is respectful of the Constitution of individual rights.
And I really super appreciate that answer. That's a fantastic way to wrap it up, but also to remind us that things are not just so quickly done by one law. Oh. It is a systematic issue, and it needs a systematic approach. And that approach is in laws and policy work too, and then real support and advocacy on every level of the system. So I thank you so much. We try to minimize things because it's such a panic, and you just want to have that one thing that will fix it. And it isn't really that easy ever, but still, I appreciate you taking my question and unpacking it and then weaving it back together. So thank you so much. Great questions in the chat, great questions in the Q&A. You guys did a fantastic job. And Clark, thank you so much for walking us through this entire American history on this amendment, unpacking it and looking at the courts literally today and what they're deciding in the next month. So thank you so much.
It's been a pleasure. Thanks for having me on.
Yeah, it's great. And I will definitely have you back, fourth or second. We can always get you on, and thank you. Appreciate it.
Bye.
Bye. Have a good one. Thank you, students. Thank you, Clark, Neily.